So I want you to imagine that a legislature just passes this law that says that only sandwiches may be served in the school cafeteria for lunch. And so a school hires a lawyer to figure out what kinds of meals the school can put on the lunch menu. And so a lawyer might start with thinking about things that are clearly a sandwich. So a BLT is obviously a sandwich. A club sandwich is obviously a sandwich. A Reuben is obviously a sandwich. So I'm going to put a circle around that. So things that are obviously sandwiches. And then there are other meal options that are obviously not a sandwich. So a salad is obviously not a sandwich. Cake is obviously not a sandwich. Pasta is obviously not a sandwich. But then we can think of some things that are closer calls. So, for instance, a hot dog. Is that a sandwich? How about an ice cream sandwich? It has sandwich right in its name. Surely it's a sandwich. And yet, on the other hand, it doesn't really qualify for what we would typically think of as a sandwich. Or is a hamburger a sandwich? And so when we ask the question, what is a sandwich, there are sort of these three categories that appear. There are these things that are clearly sandwiches, there are these things that are clearly not sandwiches, and then there is this category of things that are sort of in between. And so I'm going to put another circle around these guys. And so when we're talking about this thing called statutory interpretation, we have some cases that clearly fall within the ambit of a statute. And these are sometimes known as the core cases or the easy cases. And then we have these hard cases, which are in what's sometimes known as the penumbra. And the penumbra are cases where reasonable people could disagree about whether they fall into the ambit of the statute. And then we have these guys, which are clearly not within the ambit of the statute, which I'll just write outside. And so these cases that are outside the statute are easy. These cases that are in within the core are easy. But these cases that are in the penumbra of a statute, these are the hard cases. And this is what we would think of as cases where the application of a statute is ambiguous. And so just a quick note on the terminology, especially the term penumbra. I'm going to pull up a diagram that shows you the definition of a penumbra. So if we get a shadow cast by an object from a light source, you have this dark region which is completely blocked out from the light, and this is known as the umbra, what we would call in statutory interpretation the core. And then you have this shadowy edge called the penumbra, which is partially illuminated and partially in shadow. So it's a gray area. And then outside of the effect of the shadow is something over here. And we don't need to know about the antumbra for statutory interpretation. But this is the categories of shadow. So the umbra or the core, which is completely covered by the obscuring object, and then the shadowy region at the edge, which is partially obscured and partially illuminated. And so much of the goal of statutory interpretation is figuring out how we deal with these hard cases that are within the penumbra of a statute. And so let's talk about that. So, the more formal framework for statutory interpretation is sort of a two-step framework. So, in the first step, we just identify if the plain language is clear. And in order to identify whether the plain language of a statute is clear, we look at the text of the statute. That is the specific text at issue. Also look at the context, which is the surrounding text. And then the third thing that we look at is the statutory scheme. That is what does this text mean in the context of this statute as a whole? But notice that all of these things that we are looking at in the first step are within the four corners of the law. So, in other words, we are just looking at the enacted text of the law to figure out what a term means. And if the language is clear, then the rules of statutory interpretation say that we simply apply the clear language of the statute. But of course, statutory language often isn't clear, and when it isn't clear, then we move on to the second step, which is to resolve ambiguity. And there's a couple different things that we can look to in order to resolve ambiguity. So the main one is to just think about what is the purpose of the law. So in our example of the sandwiches, so if we imagine that this statute was enacted by the legislature in order to get rid of a surplus of bread, and so they mandated that the school should only serve sandwiches, then we might consider that a hot dog is a sandwich for purposes of this statute because it contains bread and it will help further the purpose of the statute in getting rid of bread. We might also consider a hamburger to be a sandwich because it has bread. And we might also consider an ice cream sandwich depending on what kind of substance sandwiches the ice cream. We might even consider that to be a sandwich. But we could imagine a different circumstance where maybe the legislature enacts this statute for the purpose of making school lunches more wholesome. And the legislature might have decided that sandwiches in general are more wholesome than other types of food because they have multiple different ingredients, and thus they are more likely to hit all of the different categories on the food pyramid. And in that situation, we might consider that a hot dog is not a sandwich because it doesn't really have a lot of ingredients. They're kind of fatty, not very healthy, not something that we would consider a healthy meal. And we might also consider an ice cream sandwich. That's probably not going to further the legislative purpose of making school lunches more wholesome, so we exclude that from the definition of a sandwich. And then a hamburger, I suppose you could debate it, but let's just say, hamburger has meat, it has lots of ingredients, so even though it's sort of on the outer edge of what a sandwich is, maybe we consider a hamburger to be a sandwich for the purposes of a statute trying to make school lunches more wholesome. And so you can see, depending on what the purpose of the statute is, you can kind of get a different definition of what a sandwich is. That in some cases, a sandwich is going to further the purpose of the law, so we might include that in the construction of the statute, and other things don't further the purpose, so we exclude those. And when trying to determine the legislative purpose, a lot of times we look at the legislative history. That is sort of the debates and the reports that the legislature produced when they were considering the law. And by doing that, we can get a better idea of what was the legislature trying to accomplish by enacting this statute. Now, sadly, just looking at the purpose of the law often does not resolve the ambiguity. And so a judge might also look to these things called interpretive canons. And you have a couple different types of interpretive canons. So, on the one hand, we have the these textual or linguistic canons. And these textual or linguistic canons can be helpful to resolve ambiguity that arises from the grammatical structure of a statute. So, for instance, there's one canon called expressio unius, which just means that the expression of one thing implies the exclusion of others. So, if you have, for instance, if you have a list that says A, B, and C, then this excludes D. Even if there is not an expression that D is excluded from the list, if you have included these three items, then the assumption is that anything that is not included in the list is automatically excluded. And then a corollary of the expressio unius canon is this canon called ejusdem generis, which means that if you have a law that says something like A, B, C, etc., this type of list would include letters because they are a similar character of the included items, but it would exclude numbers. And so ejusdem generis says if you get a list like this that says A, B, C, and then etc., or some other catch-all, then what you do is to figure out what's included is you look at the character of the included list and then compare that to whatever it is that you're debating and then decide whether the thing that is in debate is of the same character as the included list. And there are a bunch of these textual interpretive canons that you can look up if you have a situation like this. And so those might help you resolve some ambiguity. But then also there are also these things called normative or substantive canons. And so, for instance, a normative canon that is used a lot is called the rule of lenity. And the rule of lenity says that when you have ambiguity in a criminal statute, you interpret that ambiguity in the favor of the accused. Interpret in favor of accused. And so you can notice that this type of canon is not looking at the grammatical structure of a statute. It's just saying that for reasons of public policy, we don't want to the criminal law to harshly punish someone when it's debatable whether they actually violated the law. And so we just say that if there's ambiguity, we interpret that ambiguity in favor of the accused. It's making a policy judgment rather than simply trying to resolve the grammatical structure of an ambiguous provision. There is also one, there's also an important one called the canon of constitutional avoidance, which basically says interpret interpret a law to interpret a law to make it constitutional. And so if you have two reasonable interpretations of a law, but one of those interpretations would violate the Constitution, then you just go with the interpretation that does not violate the Constitution. So that's known as the rule of constitutional avoidance. And again, there are additional normative or substantive canons of interpretation. There's one canon, for instance, that says statutes that abrogate the common law are to be strictly construed. In other words, that we construe statutes to avoid superseding the common law. There's another one called the Indian Canon, which says that you should interpret statutes involving Native Americans in favor of the Native Americans, and all sorts of canons. And these canons also can apply to contracts, and so especially the textual linguistic canons can be used to resolve ambiguity in contracts as well as statutes. There is, however, one final item that I want to address, and that is the absurdity doctrine. So the absurdity doctrine comes into play when the plain language of a statute, the four corners of a statute, is clear, but it is also going to lead to an absurdity. And so the example that I'm going to give you about the absurdity doctrine is from something known as the Sinner's Bible, which was printed in 1631. And the Sinner's Bible contained a typo in the Ten Commandments and read, "Thou shalt commit adultery." And of course, in the Ten Commandments, as they were supposed to read, this would be, "Thou shalt not commit adultery." So this Bible was published with this seemingly critical mistake. And the consequence, of course, when you have a Bible that gives not only a permission to commit adultery, but an affirmative command that everyone shall commit adultery, one might wonder if these 1631 Englishmen suddenly all went out and committed adultery en masse. And as far as I can tell from the historical record, they did not. And the answer to that is probably has something to do with the absurdity doctrine. So even if you have a clear command from the plain language of a statute, or in this case the Bible, if that plain language would lead to an absurd result, then we disregard it and instead construe the statute to avoid absurdity. And it is this step in the process of statutory interpretation of figuring out what is an absurdity that creates the biggest division between the two main schools of thought of statutory interpretation, those being the textualists and, on the other hand, the purposivists. And so the textualist line of thinking says that the absurdity doctrine is something that we do not want to apply very often. And it is really only in these situations where you have a Scrivener's error or a typo or something that was obviously not contemplated by the legislature. So for the textualists, it is the Scrivener's error in which the absurdity doctrine is invoked. The purposivists, however, will take a more liberal view of this absurdity doctrine, and they'll say that we can invoke the absurdity doctrine whenever the plain language of a statute is contradicts the purpose of the statute, or simply does not further the purpose of the statute. And so, notably, a textualist would never look at the legislative history uh, before concluding that a statute is ambiguous. That a textualist would only look at legislative history after it's determined that the statute is not clear. A purposivist, on the other hand, might indeed look at legislative history to decide what the purpose of the statute is, and then decide that even though the plain language of the statute is clear, because the result would contradict or not further the purpose of the statute, we will just ignore the plain language and instead construe a statute in such a way that it furthers the purpose of the statute. Now, the philosophy of statutory interpretation is not something that has been settled by judges, at least not in the American legal system. Judges still debate what is the proper way of engaging in statutory interpretation. I suspect that they will continue to debate that until the end of time. But this should give you some idea of the language and the process in which judges engage in the task of statutory interpretation so that you can understand what arguments are best suited to a particular judge.